the issue of intimidation of lawyers following the arrest and sentencing. But the other issues we have raised, because we had to draw the attention of the court, we are not here by accident. The law provides, the Constitution, the UPDF Act, all provide for an accused person being represented by a lawyer of their choice. We need access to the court without let or hindrance. Today, access was much better than earlier, but outside the court, most of the lawyers are having to walk long distances.
That whoever is dissatisfied, he can take can seek reference to the Constitutional Court to interpret the opinion of a judge advocate. We can't even do that. Handle that legally. Definitely, we are not going to take that lying down.
And Aaron, we know he'll be taking action. Watch the space. The issue of intimidation of lawyers following the arrest and sentencing of Aaron Chisa on the 10th for merely trying to get access to the court to represent the client. We feel as advocates intimidated, and we raised those issues before the court. I believe we were not satisfactorily answered, but the other issues we have raised, because we had to draw the attention of the court, we are not here by accident. The law provides, the Constitution, the UPDF Act, all provide for an accused person being represented by a lawyer of their choice. And therefore, we need access to the court without let or hindrance. Today, access was much better than earlier, but outside the court, most of the lawyers are having to walk long distances, being forced to park their cars away from the court. We raised that as an issue. We are yet to receive a satisfactory answer. Then it came to the issue of amendment of the charge sheet, which we were rejecting because we wanted the issue of jurisdiction dealt with first. They read, the court ruled that the charge sheet, they will allow the amended charge sheet. It was read. An accused person who is a serving military officer was joined in the charge. He pleaded not guilty. We advised our clients not to plead because they had objections. But they are also well versed enough to know that when they have issues, they should not plead. So Dr. Besige spoke and said he wanted his lawyers to raise objection to the charges. We have raised objection to the charges, mainly on the manner in which they were brought from Kenya without any extradition order, without appearing before the court, without immigration procedures. We have also raised the issue of territorial jurisdiction. The Constitution of Uganda and the UPDF Act all point to territorial jurisdiction within Uganda. The UPDF Act appears to give jurisdiction outside, but we are arguing that jurisdiction is territorial because that's what the Constitution says. We are now waiting for a ruling tomorrow. The court has adjourned. The military has also, the prosecutor has given his replies. We are waiting for a ruling tomorrow on whether the courts in Uganda, including the General Court Martial, has jurisdiction on matters that happened in Kenya, in Athens, Greece, and also in Switzerland. We have raised, and it's for the court to rule, that there is nothing in the Constitution that confers upon the UPDF civil or criminal jurisdiction on Ugandans, and that their jurisdiction, or especially civilians, their jurisdiction is limited to disciplinary offenses of military officers. Those are the issues the court will have to rule on tomorrow. We objected to it and were overruled.
Well, it has taken us by surprise because, this is a person who is coming from nowhere. His particulars are not clearly spelled out. And when they alleged that the offences had been committed in Switzerland, committed in Greece, committed in Kenya, nowhere are they mentioning that they did it together with Dr. Besigye. So how they came up with a joinder of a charge sheet, I mean, joinder of the parties, is something which is really baffling to us. You know, you can only join individuals who are alleged to have been committed crimes together. You know, if there is a chain, I mean, the series of events involving those individuals, then you can join them in one charge sheet. Now, all along they have been talking about Dr. Besigye and Abedi Rutale, who were found at Riverside. They never mentioned this third party, this soldier here whom they have brought here. Dennis Ola, they never mentioned him anywhere. So all of a sudden, they come up with an ambush and bring up this gentleman and add him on the charge sheet. So of course they are up to a mischief. These are all choreographed things intended to cause a mischief, as I've said. But we are also prepared to deal with the same. One thing I needed to emphasize on the question of extraterritorial jurisdiction, you see, they have attempted to bring a very old case from Tanzania. Let me tell you, for us, we have done enough research on this matter. The Commonwealth position is that you cannot abduct an individual and try them elsewhere. It's not possible, it's not allowed in law. It's good we have submitted to them a number of authorities from South Africa, how some actors in ANC had been abducted from Swaziland. We have submitted to them authorities from the House of Lords of England and a couple of other jurisdictions. So the position is very, very clear. It can only be through extradition. You cannot abduct an individual whom you have not even considered to be a criminal fugitive, a fugitive, and then you subject them to martial law. That is totally out of, outside the Constitution and also the practice within Commonwealth. The judge advocate who gave his opinion, and you know, under the law, is only an advisor. His opinion, he says, it's like any other opinion. It's like an assessor, actually. It can't amount to a ruling. So we are baffled by this practice here, where you find a judge advocate whose duty in law is just to give advice, but when he makes a decision, and he actually is proud of it, that his opinion is binding, is final. And he even had the audacity of telling us, whoever is not satisfied, you are free to seek for a reference. That shouldn't have come from him. That whoever is dissatisfied, he can take can seek reference to the Constitutional Court to interpret the opinion of a judge advocate. We can't even do that. That we are going to the Constitutional Court to seek for the interpretation of it can be of the court, fine. But the opinion of the judge advocate, which opinion he renders to the court martial?
The issue of intimidation of lawyers following the arrest and sentencing. But the other issues we have raised, because we had to draw the attention of the court. We are not here by accident. The law provides, the Constitution, the UPDF Act, all provide for an accused person being represented by a lawyer of their choice. We need access to the court without let or hindrance. Today, access was much better than earlier, but outside the court, most of the lawyers are having to walk long distances.
That whoever is dissatisfied, he can take can seek reference to the Constitutional Court to interpret the opinion of a judge advocate. We can't even do that.